Okay, we'll call this Agriculture Property Standards Working Group agenda or to order. So does anybody have a pecuniary interest? Seeing none. So can I have a mover and a seconder to adopt the previous minutes?
Dan.
Oh, Dan and I'm terrible with names. Chris, okay. I'm gonna have to. So Dan moved it and Chris seconded that the minutes dated January 8th, 2026 for the Agricultural Property Standards Working Group be adopted as circulated. So is there any questions on that? So we got to carry that, right?
You gotta ask.
Motion to approve?
Yep.
Carried. So correspondence, there is none, right? So then we'll move on to the business of the working group. So the presentation by FFFPA. It's all yours. James, go ahead.
Excellent. Thank you very much. So just to make sure you can hear me okay?
Yes, we can.
Perfect. So I'm going to try and do some magic here and share my screen. Let's just do this. Uh, every system is a little bit different, so I'm going to just do this. I'm hoping then you can see here. Can you see that on your screen, a slide deck?
Yes, we can, James. It looks good.
Magic. Excellent. So what I can do is I'll kind of go through some slides. These are it's a fairly informal set of slides. You're welcome to interrupt me through, or we can kind of take questions throughout, or just whatever's going to work best. So why don't I just dive right in if that works?
That works for us.
Perfect. So this is just a little bit of an overview. There's a link to the Act here. I recommend, there's three things I recommend you look at, and we can look at them after when we're through the presentation. It's the Act itself. It's the fact sheet that we have from the ministry on the Act, and it's the Normal Farm Practices Board, which has their own website, which you can see a whole lot of information. I'm not going to necessarily go through all these, but let's just pop right through. The first thing here is what's the purpose of the Act? And really, it's this first line probably says it the best, and that's to ensure the rights of all rural Ontario residents are respected. And that you're going to find is kind of a common theme throughout. It does get into a little more about, protecting farmers from liability due to nuisances or restrictive bylaws, but we'll get into that a little bit later. The overarching part is, though, is this is meant to be a tool for everybody, both farming and non-farming. And so here you go. There's two themes, and I'm going to talk about these throughout. The one is that farmers are protected from nuisance complaint made by neighbors, providing they are following normal farm practices. So a farmer is doing something that a neighbor doesn't like. If it's one of the 7 things which we'll get into, that neighbor can essentially make a complaint, if you will. He will then go through a process which may end up at the board. That's the one theme. The other theme here is no municipal bylaw applies to restrict a normal farm practice carried on as part of an agricultural operation. So in this case, a municipality puts in a bylaw. If a farmer says, I don't think that bylaw should apply, they can file a complaint. It'll go through the process and eventually can end up in the board, and the board will make a decision. So 2 really distinct streams. One is like a farm producer and their rural neighbor. The other is a farmer and the municipality that they are farming in. We're dealing with them together because they do have a lot of common themes. So the Act itself is essentially establishing this Normal Farm Practices Board. That board is an official tribunal. So basically, when we refer to the tribunal, we're referring to the Normal Farm Practices Board in this case. They really have 2 things, if you will. The one is, does the operation meet the definition of an agricultural operation? And then if the farm practice is normal, considered on the evidence provided. And these two different questions, we're going to get into those because you're going to say, what's a normal what defines an agricultural operation and what defines normal? So we're going to get into that, but that's essentially where the board comes in. Probably the main takeaway here is the board is the only authority that can say whether a farming operation is considered under the definition of an agricultural operation or whether the practice is normal. That's one big message from OMAFA is as much as we can help mediate these things, we have no authority to say essentially you're right and you're wrong. All we can say is all we can do is help mediate the process, and then if a decision needs to be made, send it to the board. I'm not going to get into this as much. The act was created back in the late 90s, so almost 30 years ago. And so some of these aren't quite as how would you say they tended to be a little slanted towards the farming community. And really, so some of the messaging was around that. So this idea of protecting farmers from complaints and providing rural residents clear guidance and providing rural municipal leaders with clear definitions and such. Really, it's more of, I would say, a two-way street. And so it's more about ensuring farmers and their neighbors can work together and ensuring municipalities and farmers in that municipality can work together. So that's kind of something that's sort of changed a little bit, but the important note is this is not meant to be a one-sided piece of legislation, which goes right into this next slide. So the FFP does not give farmers the right to do whatever they want on their property. And nor does it allow farmers to violate any sort of other act, any sort of other provincial act, Environmental Protection Act, Pesticides Act, Clean Water Resources. Prime example, so a farmer is putting manure into a waterway, they can't say, I'm a farmer, I can do whatever I want. No, that's a violation under the the Water Resources Act. MECP, the Ministry of Environment, can come out, lay charges, do all that sort of stuff. And this bottom line here, certainly there is a responsibility to act appropriately. And really here, the farmers are only protected in the nuisance side or from when there's normal farm practice happening. I'm not going to get into this, but the definition of an agricultural operation, it's somewhat self-explanatory, but you'd be surprised how complicated this can get. And really, again, it's not for OMAFA, it's not for it's not for the neighbor, not for the farmer, not for the municipality to say you are or you aren't. Really, that regulatory authority lies with the board. And so things get muddled very quickly in terms of, yes, it's a farm, yes, it's doing farm activities, but maybe they're doing something else. And is that considered still part of the farm or not? And those are, there could be a whole meeting on that. And really, the answer to that is it depends. And it's hard to say. And the authority on that is the board itself. Again, when it comes to what's a normal farm practices, you can see the definition there is conducted in a manner consistent with proper and acceptable customs and standards, et cetera, makes use of technology that's in mind. This is again challenging, right? And we love it when we get these things with a farmer with average to above average management skills use the same practice on his or her farm under the same circumstances. There's a lot there. And that's where then the board has a very stringent system of working through that and deciding. And guess what? It might be a similar situation on two different farms, and the board may come up with two different situations depending on that. It's kind of that last point there. There are a lot of factors that come into play there. So when I talked about those two themes, I'm going to talk about the first theme first. This is nuisances that essentially between a farm operation and a rural neighbor, or some cases another farm operation, what have you. So there are specific things that are nuisance things that can be dealt with through the board. Odor, light, vibration, smoke, noise, flies, dust. And so again, here it's stressed the bottom there. These nuisances are not, if there's something that's harming the environment or causing any sort of basically illegal activity or harmful or a safety concern, these are covered under other legislation and not here. So this is really the part of basically rural neighbors that have conflicts with each other. When we move to bylaws, it's a little bit different. And so we don't have those seven things per se. It is basically anything that any sort of bylaw that is deemed to be infringing on normal farm practices at that particular location would be then something that a farmer could make that complaint and go through our process and potentially end up at the board. So there's a process. And so before these things go to the board, and before it's actually rule number 60 in the procedural rules of the board. Yes, it is very technical and it's great reading if you're looking for something to do some night. But before the board can hear an application, there is a dispute resolution process, and that involves the ministry. Now, the good news is 98% of the cases are resolved by the ministry through our agricultural engineers or through environmental specialists that are basically doing it. It's only when the case is not resolved that the parties apply to the Normal Farm Practice Protection Board for a hearing. So I'm going to kind of stop there for a second before I go into kind of a little more of the kind of nitty gritty of how we go through this process. But does anybody have any questions right off the top there?
Wayne, you're the chairperson. Okay, does anybody have any questions? Dan, go ahead. Yeah, I got it.
Yeah, that was a good presentation, James. When was FFPPL established? And typically on a year, how many complaints or farmers or residents call FFPA for support, and how long does it typically get to be resolved? Thank you.
Excellent. 1998 was when the act was first established. It's gone through a few iterations. It's a little bit different now than the way it was before, and that's just kind of as a program matures. As far as numbers, it varies fairly substantially. It can go into the hundreds in terms of complaints. Now, the very large, vast majority of those are nuisance complaints between neighbors that we talked about under that first theme. Bylaw ones are significantly rarer, I would say, and it does kind of depend on the year, and it does they kind of come in sort of waves, if you will. The average time to kind of get through them really varies. Often when we talk about those 98% that are resolved pretty quickly, it's about getting the parties together. So this is the unit that I'm responsible for. It's a mediation role, and we are completely neutral in this process where can the parties come to some sort of agreement? Now, with a producer and a rural neighbor, that's a fairly straightforward kind of yes, no question. And it's a bit about for us educating the non-farming neighbor. Are you aware that yes, manure smells and there'll be this time of year when they're going to be spreading, and going to the producer and saying, you realize you have neighbors beside you. Are there things you can do to prevent odors? And can you work with your neighbors so that you're not spreading the same day they're having their family reunion or whatever, right? It's those kind of things. And very surprisingly, most of those get worked out very easily. If that's not the case, once it goes to the board, it is in the board process. It does involve a quasi-judicial process where there's a hearing has to be established, there's documents, that sort of thing. That's a little bit dependent on the case. Some of them can take a little bit longer than others. But essentially, the board hears it, makes a final decision, and then that decision, basically, it's kind of goes from there. Was that the three, or was there a separate question there too?
Nope, that answers my question. Thank you.
Perfect. See, there's a hand up there too.
Yes, thank you very much. And through you, Mr. Chair, very informative presentation, James. Can you talk to us about farming practices, for example, if machinery is left outside that they don't have they don't have enough shed storage for machinery. Is that acceptable under the farming practices or not?
So, great question. From if you go back to those two themes, that's not one that would. So that's a hard one. So a neighbor says, or wants to make a complaint about there's stuff left outside, and it's not helping our neighborhood and such. That's unfortunately not one of those things that the board would hear, and they would ultimately say it's not one of those. It's not under noise, flies, dust, and whatever. However, under the second theme, so if a bylaw was put into place that says you can't leave all your equipment lying outside the laneway, whatever, it would be if a producer wanted to go to the board and say that bylaw is restricting my normal farm practices, it would be a very interesting case at the board, and I'm not sure really what would happen there. So basically the process would be if that were to come in, so the municipality puts in a bylaw that says I'm just making this up, whether like you're not allowed to have tractors stored out in the elements, whatever it may be, because we want to have our municipality looking good for the tourist season or something. I'm making this up as I go. What the farmer would have to do would be to say either abide by that bylaw or make a case to the board that what they're doing is vital to their farm operation and considered a normal farm practice. I would say that may very well be a hard sell, but I can't speak on behalf of the board, what the board might come up with, and depending on all the circumstances, that sort of thing. Is that kind of the question you were getting at?
Yes, it is. And so for clarification, as part of if we ever put a bylaw in place, part of it could be that, for example, there could be trucking businesses in
Yep.
our municipality that it's impossible to keep their trucks inside, so they're parked outside. So is there a way that if we chose to implement a bylaw, we could address that as being a permissible farming practice?
So here's the rub. Um, the and this is hard to kind of get across sometimes, is that uh, municipalities are free to make whatever bylaws they want within. I know you can smile when you say it. Essentially, make the bylaw. The bylaw is in force until tested, and when that bylaw is tested, it's hard to say what may be the answer. So one of our things we always get is kind of going back to that slide of what does the farming up not do? Um, it's not about a right to farm. One of our things that really annoys us is, well, we can't talk to them or we can't address that because they're a farm and they are allowed to do whatever they want. And so, no, there is no right to farm legislation. There is legislation that addresses conflicts, and there is legislation that can help that question of, is this bylaw infringing on farming practices or not? If this bylaw is not infringing on the farming practice, then same, just giving examples, like these are not cases, these are not anything that can be seen, but so there's a trucking company that has a dump truck, and there's a farm that has a dump truck. Both of them have their dump truck parked outside, both of them in the same condition, and a bylaw is in place. It can't be that the trucking company is allowed to keep their truck there and the farm is not necessarily, right? Or sorry, other way around. Yeah, like it can't be that this bylaw applies to the trucking company, but doesn't apply to the farmer necessarily. That's not how it works. It's more about how is it integrated appropriately into what the bylaw is trying to achieve. Where the board kind of weighs into these things is the issue about farming, or if this wasn't a farm, like how is it impacting the farming operation itself? Is it enabling normal farming or not? That's where the board comes in. So it's kind of a roundabout way of asking your question, but it is complicated. And it's not that municipalities are not allowed to implement bylaws. Municipalities are able to implement bylaws as they see fit. And if farmers feel that that bylaw is restricting their operation, then they may make that case to the board. And then the board can make that decision. I'll get down to it later on. I have a few extra slides here that we can kind of say, here's what the board can and can't do. Does that help? Sorry, that was long-winded.
Yeah. I was just trying to get at the fact, like, for example, some farm equipment is quite large in width and may not fit in a shed.
Exactly.
Is it permissible for it to be stored outside or not?
Yep. And so let's play that out. There's a large tillage piece of machinery that's outside, and a bylaw is put in place, and the producer says, "No, I want to go. I'm complaining. I don't feel I should have to meet this bylaw." What we would do is our ministry, when that complaint comes in, we talk to the farmer and say, "So what's going on? How is this implementing your farming operation?" And we would also talk to municipality and say, "Municipality, what are your goals of your bylaw here? What are you trying to get at?" And frankly, we would work back and forth to say, is there a solution, right? Like, yes, this has to be outside, but maybe it can be here, or there's or something about it, right? So it's been trying to find that mutual agreement on something. And it's only when you can't find that mutual agreement that you would go to the board and the board would make that decision. The challenge we have is it kind of comes back to that right to farm legislation where some producers, and I'm not generalizing here, not, but some people feel that they can right off the top say, no, that bylaw doesn't apply to me. Well, they don't get to say that any better than any municipality gets to say. That's where the board is the only authority that can say this bylaw applies or doesn't apply. And so we try not to get involved in some of that. Will it apply or will it not? Because it's one of these things where the bylaws are enforceable until told otherwise. And the only one that can tell otherwise is the board.
Okay,
Make
thank you.
sense?
Thank you.
So
Okay.
sorry, go ahead. Yeah.
Go ahead, Nita. Or did you want to go ahead?
I'm good. If there's another
Okay.
question, by all means.
Okay, go ahead, Nita.
I have another question, or I have a question, but perhaps you're going to cover it further on into your presentation, but it's about the authority of the board. So you talk about a board's decision, I assume is a final decision. Are you getting into that part of the presentation about is it
Yeah.
upheld in court of law and that sort of thing?
Yes and no. So the ultimate is the point of putting the board in place was to avoid the divisional court system. And so these things can be tested in court too, if need be, right? And it becomes almost that, well, in between neighbors, it's a civil matter, right? But between it's a little bit complicated there. But the upshot is the board has a decision if we want to pursue a further legal routes. People are able to do that anyways, right? It would just then go through a regular divisional court and things would last longer. And yeah, So it's a mechanism to help avoid the normal court system, if you will. That help?
Somewhat, yes, thank you.
It's hard to say anything is truly binding. If that, and that's kind of your question, right? Is the board's decision final? Well, yeah, it's a final decision. That decision is a public document. It's posted on Canly and it can be read. Are there other avenues that can be done legally? Maybe. So if parties choose to go that route.
Well,
So
I asked that because I was once on a tribunal board. It was a federal board and the decision was final. You couldn't go to a court of law on that. So I assume that this is a little bit different and the act, that is, I mean, that is provincial or is that federal?
it's a provincial act.
Okay.
So yeah. And so now see now you're getting me worried. I should probably read it again in terms of the binding nature of it. But so yeah, I am being recorded here, so I better so it'll be good just to confirm for sure that there's not something that says the decision is binding. But my understanding is binding to the extent that that's kind of it's a final decision. If something wishes to happen after that, it can. It is different than some of like some of our other sort of tribunal processes.
Okay, Florence has a question.
Hi, James. Clerk Florence Witherspoon here. My question is kind of along the same lines as what Anita was. Is the board considered like a quasi judicial board?
Yes,
It is? Okay.
I will show you. I'll get to their website. So
Cool.
let me finish this and then I'll show you the website as well, and then we can kind of talk through.
Sounds good. Then it's just kind of treated the same as any like Ontario Land Tribunal, that kind of
Yeah.
thing as well. Okay.
Yeah, exactly. And they're very similar to our Agriculture, Food and Rural Affairs Appeals Tribunal, AFRAD as it's known, and essentially similar members in both. So just really quickly here, so I kind of talked about this already, that our role is really that neutral third party about providing education and advice and encouraging the communication. And then if that fails, then to start the broader process. Really how things work is, and this is more some of our documentation that we refer for our training purposes and such. Our Agricultural Information Contact Center is the main way to get in touch with the ministry and essentially then get the details and refer to one of the environmental specialists in our ministry in my unit. We then take it from there, try and figure things out. We talked a bit about what we're normally doing is, outlining best management practices. There are many fact sheets and info sheets on how to deal with things. For example, bird bangers in the Niagara region and often in some other regions now, there's a fact sheet about here's kind of what are considered the best management practices for using these things. If you're not doing it per that, you're going to have a fairly big uphill battle if this goes to the board. If you are, then you may very well be, you have a little more of a, you have a little more of a case behind you. The limitations here, this is a bit of this kind of process. If parties don't want to talk to each other, we can't force it in the mediation stage. And we're not involved when there's any sort of potential violation of a federal or provincial law. This is where it gets a little interesting because we're facilitators. We don't, so these big questions again, is it an agricultural operation? Does it meet the definition of an agricultural operation? We can provide advice. So for example, if you don't have a farm business registration number and you're doing some maybe sort of more hobbyish, it could be seen as hobby activities, the board might say you're not an agricultural operation, we don't have any jurisdiction here, case dismissed. As far as and then whether it's normal farm practice, same deal. Generally speaking, because odors are one of our big ones, and when to apply nutrients, that sort of thing. If you're inconsistent with the nutrient management, you're likely going to have an uphill battle if it goes to the board. They do talk about on the Canley website, you can actually review previous board cases. That is noted, though, that these are not precedent setting. And so the board essentially reserves the right to say there are many circumstances that, while may appear similar, are not necessarily going to come to the same resolution. And this is just some other information here. If they're not successful, then essentially we let the board know that parties have not come to a hearing, and we essentially give some information to the board. The board then has three answers. Actually, I would say, yeah. So when it comes to if they've decided that it's an agricultural operation, sorry, that's kind of the first question. Either it's a normal farm practice and may continue as it is, not a normal farm practice and therefore must stop, or will be a normal farm practice if specific conditions are met. And what that kind of means from what that means essentially, even for the municipal ones as well, it's a normal farm practice and therefore the bylaw that the municipality has created does not apply. It's not a normal farm practice and therefore the farming operation must stop that practice and be in compliance with municipal bylaw, or it will be a farm practice if these things happen. And that could be if regular setbacks are established, or if, I don't know, it could be anything, right? So the board has that right to put some site-specific conditions in place. So that's all for that. Let's see if I can get my mouse back here so I can end my show. And what I'm going to do, so this is our actual matter of fact sheet that we have. So you guys probably see yourselves in there too. If I do that, that might help. This goes through a lot. I highly recommend reading through this. There is a section here about the municipal bylaws. Essentially, kind of one of the neat things, if a bylaw hearing is held, anyone that owns property within 120 meters of that site is entitled to be notified of the hearing and may participate. It kind of talks about here that very small percentage of these involve municipal bylaws and such. So a lot of good information there. Essentially, if you just Google the search for a normal matter for fact sheet, normal farm practices, you can get that. This is the actual Normal Farm Practices Protection Board. And this would be where I should be looking to find about the binding nature of it. It's one of these things where you do these so often, you have too many different pieces of legislation. You're like, no, which act is that again? So anyway, so it would be here. But they also have, I highly recommend, if you go to decisions, you can click on that and find various decisions. Some of them will be about, okay, it's going to go in here and might not do it depending on where I am. Anyways, it is a process where you can search things up and accept cookies, and you can actually go in here. So these are various decisions about things that you can actually go in and read. You will find ones here about municipalities. Those are the ones that I would suspect from your point of view, kind of what you can read and see. The other thing here is the act itself. If I just go like this and type in binding, they don't actually say it in there. Okay, so I thought that would be too easy, but I thought I'd check while I'm here. But another great resource, it's a fairly straightforward act. But between that, the fact sheet and the board website is a wealth of information. So I'll stop there. Certainly any other questions?
Okay.
Happy
Any
to
other?
take them.
I have a couple if nobody else has a. Okay, anybody else have? Yeah, I'll go last or. So my question is, who is on this board that you're talking about?
So I honestly couldn't tell you at this point in time. And the reason for that is the board is arm's length. So my position is in the ministry as that third party mediator. I actually, quite honestly, don't follow the board that closely. When it'll actually be on the site there, I think it actually gives who the members are or who can sit as the board at any given time. And
Okay, thank you.
and so not all members are on it, and like if not all members are necessarily part of every hearing, I should put that in.
So you made reference in your presentation to spreading manure beside a waterway. How far are you supposed to stay away?
So Nutrient Management Act applies. Generally speaking, it's your 15 meters. There's pluses and minuses, but yeah, I would recommend our nutrient management regulation has lots of that in it as well. And there's depending on whether it's bare soil, covered soil, or like a permanent crop or buffer strips, that kind of thing. But this gets into then, yeah, should Ministry of Environment, Conservation and Parks be involved in some of those types of things? Then yes.
Okay, and another quick question. So this happened a few years ago. A farmer in the middle of summer spread, it was really raunchy manure right across from a trailer settlement, and he left it there. And the odor lasted weeks. Would that apply to something you would have to deal with?
Yep. And what would normally happen on those cases would be any of those residents could make a complaint. And what we would do is let's play that out, right? Manure is spread, it's not incorporated, it's just sitting there. There are residences nearby, and one of those residents calls our contact center and says, it smells really bad here. You have to do something. What we would do when we take on that case, we would have the discussion with the real neighbor. Okay, so where are you located? What are the circumstances? What's happened? And then we would talk to the farmer and say, what are your circumstances? What's happened? Why did you why did you put it there? And then work through to say general questions like, is there an opportunity to incorporate this manure? Or is it put on a standing crop? Are there essentially, is this a one-time thing or are you planning on doing this every year? Working through that and sometimes getting that farmer and that rural resident together, sitting down together and saying, can you come up with a mutual solution? The answer is no. Mediation has failed. That resident has the ability to go to the board and say, I would like to file a complaint. The board would then hear the process. Both the resident and the producer could self-represent themselves at that hearing, or could seek legal advice and be represented that way too. And the board would hear both sides and say essentially what has to happen. The challenge with some of those is the reality is the odors probably may very well be gone by the time it gets to the board. Having said that, the board may wish to say this is not an acceptable farm practice, do not do it again. Or maybe the resident and the producer could say, okay, next time we know it's a normal thing, we know you have to do it because the manure piles or the manure tank's full and you have to get that out before your next animals get in, after your soybean harvest and before wheat's planted, or whatever it may be, right? And so there's a lot of dependencies there.
Okay.
How's that for a
Yeah,
roundabout, not directly answering your question?
I didn't figure it would the initial time, but the next time I figured that would solve the problem.
Yeah.
Okay, Florence has, and then Anita.
Just one further question for me. Is there a fee for filing with the tribunal?
You know what? I don't think there is.
Because with the Ontario Land Tribunal, if there's an application and it's
Substantial fee.
appealed, they must pay $1,100 or something to go ahead. I'm just wondering
Yeah.
if there's a fee for a complaint to be filed.
So no, that I'm aware of. There was, so don't quote me on that. We have done a lot of removing fees. I think there was like a $25 fee at one point. But I do not believe there is. You know what? I can just do that right and actually be on frequently. There should be a frequently asked questions on the board website. I can get back to you to confirm that, but my preliminary answer is there is no fee.
Okay, thanks, James.
And the reality and the reason is like this is not meant to be an economical burden, so to speak.
Okay, Anita, go ahead.
Thank you. I realize that the answer to my question is probably dependent on the caseload and the workload of the board. But is there an average turnaround time, say for a complaint that isn't in that 98% that's resolved at a local level or through mediation? Again, like the complaint is filed, they try mediation, it doesn't work, it's going to go to the board. First of all, does the board make a decision at that time, or do they ponder it for a week and do some investigation and then come back with a decision? Or is that, and then how long does it take from the original complaint, go through mediation and to a board decision?
So you're right. The answer is it depends. It also depends a bit on the circumstances of the issue. One example I can give is actually a very complicated case. It'll be coming out shortly here. Is that depending so in cases where there is a number of complainants or some of these more, it's up to the board to determine an urgency point of view. However, they still have to issue a notice of hearing. There might be notices of procedural orders. Then there will be, when there's a hearing, there will be timelines to submit documents. So that can take things on. There is a controversial case underway right now that has kind of gone through an expedited process, and it is kind of in the time frame will be measured in months. So not a year by any stretch of imagination, but not something that's happening overnight.
So follow up to that then, James, does that mean that I guess depending on the case, there are certain times where a decision would be expedited to the board because of the natural circumstances surrounding that. But if there is no urgency on the decision, it could get pushed back and get behind in the docket behind something that is more urgent.
I wouldn't necessarily say that. There is not. There is not. So when you think of the land tribunal, when applications are in the like hundreds, if not thousands, this board is not like that. There are not a large number of files, so there is a real desire to get them heard as fast as possible. And again, it is more so on the complexity that is the length of time versus what the board would deem something that needs to be heard or not heard kind of thing. And again, board's position as to how they decide how and when to hear cases.
Final question. So I understand that I would say that the board generally makes a decision to remediate the situation, and going back to the manure situation, it's remediated, or the trucking example that was given, the issue is remediated. Is there ever a time that the board would fine or I don't know, how do I put that? Issue a fine that's associated with the decision as well as the remediation of the problem?
So good question. The board doesn't have authority to say what you did was wrong. Here's a fine. The board, and it's one of these things where the board can find, so in the neighbor ones, right? So the board can find that here's what the farmer has to do. If the farmer doesn't do that, so think of neighbor ones, right? So it says you must do this. If the farm doesn't do that, it becomes that civil matter in terms of the person that's complaining that says, it smells, and the board says, well, you're not allowed to do this anymore. If you do it, what happens is the $1 million question, right? And it's one of these things where you're not in compliance with an order of the board. And what does that mean? Oftentimes it means if that rural resident were to go to court and go before a judge and say, look, I have something that says a farmer can do this from the Normal Farm Practices Board, and they're still doing it. It would then be the judge decides what happens, right? Or what it may be. So it's not the board itself that's doing that sort of enforcement and compliance of it. No, that gets complicated in some senses, right? But yeah, and generally speaking, for in general, when a board issues a decision, that decision is followed. It gets interesting when and if that decision is not followed. So in the case of a bylaw, let's just play this out here. So a farmer goes to the board and says, this bylaw is restricting my farming operation, my normal farm practices. The board says, no, you are not an agricultural operation, therefore that bylaw still stands. You as a municipality are unable to enforce your bylaw however you see fit. Sometimes enforcing your bylaw is a little bit challenging in terms of if your bylaw says if you violate this, you will pay $100 fee or $100 ticket or whatever it is, you might find those $100 tickets pile up, right? And then you would follow your normal municipal process for what do I do when somebody violates a bylaw. So and that's when it gets hard.
Okay, you're good, Anita. I'd like to thank you, James. That was an awesome presentation, and good evening to you.
Well, thank you. I should get back to you regarding fees and regarding the binding nature of the board. Best just to follow up with Florence. Is that the best idea?
Yep, that works. I just also should mention that James did mention that if we got further along and there were some other questions that needed to be asked about the board, or there were other staff members that he might be able to think of who would be better qualified to answer, that we could ask him again. So I thought that was very generous of you, James, and much appreciated. Thank you.
Excellent. Well, all the best on your work here.
James,
So-
I have one further question. The presentation you made tonight, would it be possible to forward that on to Clerk Florence, and then she could have that, and if we need to use that perhaps at an upcoming open house or things like that?
Yep, I'm happy to do that.
You're the best. Thank you, James.
All right, thank you.
Thanks again, James.
Bye now.
So we'll move on to 5.2, the property standards bylaws, local samples, and Florence.
So I did give you all a lot of information. I realized the ask was if there's any bylaws that are specific with agricultural implications. And if you did get a chance to dive in, you'll see that not really. No, not in Huron County and not in our neighbors to the north. I did do in kind of preparation, just kind of a little bit deeper dive. I did do a word search of agriculture, farm, FFPA, and normal. So like normal farm practices. A few of the municipalities, notably Blue Water, Morris Turnberry, Huron East, had no reference to any of those. So in other words, it's a blanket across, the property standards applies to all properties, no matter what the caveat. Some municipalities did reference the Farming and Food Production Protection Act, which we just talked about. There's a one-liner. It's the same line in all of the in the bylaws, and it basically says that this bylaw does not apply to prevent a farm meeting the definition of an agricultural operation under the Farming and Food Protection Act as amended from carrying out a normal farm practice. So that kind of is plugged right in those bylaws. And there were two, I believe, that had that right in there. Central Huron did talk about farm buildings specifically. It wasn't, when I did review the bylaw with the with the bylaw enforcement officer, we weren't convinced that it was cleanly written, and we were very grateful that it's not our bylaw. Humor insert right there. Sorry. North Huron talked about making sure that no fill was left uncovered as long as it's not being farmed. And South Huron spoke to the storage of materials in non-residential zones. And it spoke to specifically about decaying animals and making sure that there's a proper location and a proper storage container for those, for that circumstance. So the long and the short is that the ACW property standards bylaw is the only one in our local vicinity that has any kind of explicit exemption. So I thought I would just add that. If there's any questions, I'd be happy to answer.
So does anybody have any questions on it? Just Chris, go ahead.
Yeah, have they, when you were talking to any of the other municipalities, have they ever had to deal with agricultural issues? I know they've got a bylaw that covers it, but what kind of examples have they had to deal with?
Nobody expressed anything that was technically outside of the normal. So just like we would go to a place in a settlement area and deal with a property standards issue, we would deal with it in the same way. They didn't say that there was anything that highlighted that was complicated.
Yeah, because there's quite a difference between like a guy with agricultural machinery sitting up behind his barn is different than a guy in town with piles of lumber stacked.
With lawnmowers stuck on the front lawn.
Well,
Yeah,
exactly. So
exactly.
I didn't know if they handle it different or if they.
It's not handled differently. No, and I mean, I don't know because we don't do it here.
Yeah.
But the approach would be the same way that we would do it with bylaw enforcement.
And that's where the normal farm practices would try and kick in.
Would kick in. That's right.
Anita?
I maybe should have asked James this, but I think I know the answer to this. Your response triggers a question. So you know how with the short-term rental, people could call in and make a complaint. And as far as I remember, that was an anonymous complaint, correct? Yeah. So I'm assuming that with the board, the FFPPA board, I'm assuming that it could not be an anonymous complaint then. Would you summarize that from James?
So my understanding from working with boards and tribunals is once you make a formal complaint in that capacity, it becomes a public platform. So the complaint is no longer confidential. No.
Okay, so that's kind of what I calculated as well. So just to play like a devil's advocate, if this council decided to go with no exemptions on property standards, similar to the 6 examples that you gave us, that means that similar to the short-term rentals, somebody could make an anonymous complaint, right? And stay anonymous, right? But the way it is right now, is it still anonymous? Or I guess I'm trying to grasp whether or not if we had no exemptions and you stay anonymous, is it better that way than to have a complaint system where you have to give a name and so on, and then it becomes a bigger neighborly conflict? Can you just weigh in on that if you know where I'm going with
Yeah, so so any bylaw enforcement complaint we receive is confidential. I mean, it's a municipal freedom of information. It's protected under that act. So if somebody complains, nobody has a right to that information of who it complains. If they do decide to, if we do put it that way and it can't get resolved, or it becomes, a determinant of non-farming practice, and the complainant chooses to bring it to the board, they are waiving their rights to that confidentiality. But all bylaw enforcement complaints that we receive are all, they are all confident. We do not disclose the name of the complainant. And if, if somebody asks for an MFIPA, there is a flat out exemption in there that says anything that's pertaining to a bylaw enforcement or a law enforcement case is considered private under the Act. Does that answer the question, or?
I think it clarifies it.
Okay.
Yes, I think I'm just trying to find the avenues in my brain where I want to go with that, but I think you've hit it and
Okay.
clarified it.
Okay, Mark.
I just want to clarify, we don't receive anonymous complaints. You have to have your name with it. So if you're going to file a complaint, it's not. But once we receive it and we have a legitimate name with associated, then it's anonymous. We don't share it.
We have a general policy. We do not accept anonymous complaints. If somebody sends an email to me anonymously, I will reply and say, unfortunately, unless you sign your name to this, I cannot proceed with it. Most of the time they will come back with a, you can understand why they submit it to be anonymous. They want to make sure that they are protected. However, we require that in order to proceed with any investigation.
Okay, I think Dan had his hand up first, and then we'll go to Lynn.
Just a question regarding this conversation about the anonymous complaint. The name is taken upon complaint, but is it, I guess it doesn't matter if the person's from the municipality or anywhere, it doesn't matter. I guess for property standards, in my mind, the person should be from ACW if they're going to complain about a property, but that's just, I'm not thinking it through maybe.
By virtue, any person can make a complaint. They can be driving through, they don't like what they see, they can make a complaint. Generally speaking, when it comes to bylaw enforcement, the bylaw enforcement officer will contact the complainant just to get a bit of a broader, a little bit more context on what's going on. They'll visit the site, they'll do a little bit of investigation. I mean, and then there's, not to consider something frivolous or whatnot, there's always a process, a due process in determining what next steps are taken.
Okay, Lynn, go ahead.
So Florence, I just wondered, with your review of all of the other local townships, property standards, bylaws, is there a reason ACW is the only one that has an exemption for agricultural properties?
I don't know if I'm the right person to answer this question. I haven't been around long enough for that. As long as I've been around, the exemption's been there. I'm going to let Mark maybe.
So yeah, the bylaw has always existed like that. I think I mentioned at the last meeting, we've attempted, probably this is the third time, just not attempted, but we brought it back just to see if there's any appetite, and the council at the time were adamant it wasn't. But one thing about this council and this committee here, they've taken the next steps to take a look at it. So I think everyone's afraid of what it is, and I probably said what it was. I said at the last meeting, I can say it again. I don't think anyone's going to complain about a 100-acre farmer that's doing whatever it is. I think most of our complaints, or we anticipate most of our complaints, are the smaller holdings, AG 3, 4, whatever the case may be. Those are the ones who probably get complaints with, a 2-acre house with a lot of crap sitting around it. I don't think I've ever heard of anyone complaining about a general farm, unless it was a derelict building that just doesn't look good from the road on a 100-acre farm. That may be the case, but I think sometimes people are afraid of the unknown, and I don't think there's much fear here, but that's my own personal opinion.
Okay, Glenn, go ahead.
Thanks, Mr. Chair, and I agree with our CAO's last comments. And I'll also suggest to the committee that there may be merit in the inclusion of the Huron-Kinloss second last paragraph that indicates that the key exemption, and there is an exemption, that the key exemption is a specific provision stating that it's not applied in a manner that prevents a farm from carrying out a farm practice. And there may be merit, I will suggest, in us to consider that if we are to move forward. Thank you.
Thanks, Glenn. So Doug, go ahead.
So when Jim Mitchell was talking, he talked about recent decisions of the board. And I wonder if our group here thinks the last 3 or 5 recent decisions would give us a flavor for, regardless of what the issue was, just how it made the decision. So in getting the copy from James, if we could ask for the last 5 decisions, I would think it'd be something worthwhile.
Okay, Florence?
Yeah, we can certainly do that. I'm interested out of pure curiosity myself to go have a look at them. So I think it's worthwhile that the committee have a look at that, or the working group.
Dan, go ahead.
This is really just a comment. I read through a majority of the neighboring municipalities' bylaws, and all of them with yards, specifically yards. The vehicles and equipment, and it goes on and on what can't be sitting around. And also driving around Southern Ontario, there's so much stuff sitting around. I'm shocked that their bylaws are stating what they state, and there is so much stuff sitting around, and I'm just shocked. I mean, I don't know how I'll find out, but it would be nice to know, how many complaints are out there, and what's being done about it. And maybe it doesn't really matter, but I'm just really, really surprised on the amount of stuff that's labeled as shouldn't be there, and it is. That's all.
Okay, I totally agree with you. I parked a trailer in a gravity box across the road when winter happened, right? So it's still there. So I get where you're coming from. Florence?
I think it's important to remember, in the context of reading bylaws, there's 2 things. The first is that, and I'm wondering how far I should say, but inherently a municipality doesn't have to enforce its bylaws. We're not obligated to. Number 2 is that the majority of municipalities, bylaws are enforced on a complaint basis. If there's no complaint, we don't go looking for it. So, and in the context of changing bylaws as well, if this rule got changed, and it's been talked about before at the council level, where you would have an influx of complaints as a result, or that's the fear, is that you would have an influx of complaints, and all of a sudden the bylaw enforcement needs a full-time job. But after a while, people start to get used to the way things are, and then it kind of, you carry on. So I think it's important, and I completely, like, I am the first one to know that when I drive through Southwestern Ontario and I see certain things, it kind of blows your mind that it even exists, because for the most part, every municipality has rules that apply that are not being, I wouldn't say necessarily that they're not being enforced, but the hurdles for compliance may not be worth the effort to get there. And that's largely, maybe a small piece of what we're dealing with here too.
Anita?
Just to piggyback on that, I think it goes back to that if it's generally going to be a neighbor that's going to complain. I think I'm safe in saying that it's generally a neighbor, and they're afraid of repercussions. They don't want their tires slashed, or they don't want their windows smashed, or whatever, right? So they just put up and shut up.
Okay, I have a quick question if anybody else doesn't have any. So you were South Huron, you were talking about decaying animals. So I've noticed it's mainly pig farms that have those bins. So are they allowed? I haven't seen them lately. So are they allowed or not?
I don't know what the rules are in terms of disposing animals necessarily. I mean, if you see them around the countryside, I think it's probably a good practice to have them. I don't know if that I have that much more comment on that.
Okay, I was just curious when you said that. So, okay, Doug?
Well, when I see them, they're like a 4-yard dumpster, and they're right at the end of the driveway so that the truck can come in and dump the bin and be gone. And they must call them and say, we've got 3 animals in there, and they ask them to come.
I think they're on the edge of the road because they don't want that truck in their yard
Well, that
for
too, but
disease reasons, right?
yeah,
But have you seen them lately? I haven't.
Yeah.
They're still out there. So, okay.
Yeah, I see them around, but I think that would be a normal farm practice.
Okay. Yeah, me too. So, no other questions? I'm seeing none. We'll move on to 5 point. Oh, my mic's off again, but that okay?
I don't have too much to add to this. I did listen to the meeting and kind of summarized the comments based on, so largely, I think this was Lynn and Dan who were interested in a bit of the history and what the process is in terms of what we do when we receive a complaint, and how we've approached dealing with agricultural property standards complaints when they come in. If there's any questions on that, or if there's any comments.
I did have a couple of questions. So, so if there were 8 complaints and 2 involving properties located within agricultural zones, so what you mean by that is that 2 of the 2 complaints you're talking about there are on agricultural land, so they
Yeah.
do not fall under the property standard.
That's right.
Yeah, okay.
So so there would have been, did I say 6 or 8? I can't remember.
Said 8, and
8,
2 of
yeah.
those were
Yeah.
with it.
So in the course of a year, we have several bylaw enforcement complaints of various different bylaws, parking, noise. 8 of
Yes.
them are property standards, and
Okay.
2 of those complaints were directed at properties in an agricultural zone.
So I guess my ask about this information was, why are we here? Right? So if
Yeah.
there were 6 other complaints that
Yeah.
were relevant to what we're looking at,
Yeah.
what are they about? And why, if it was brought to a council meeting in
Yeah.
September 23, and I looked at the minutes, I went back and looked at council meeting minutes, and I didn't see anything
Yeah.
relevant in those minutes to property standards. So I guess that's kind of what I was asking for this for, because I kind of came into this kind of a clean slate.
For sure.
So I don't know. So what's the nature of those other 6 complaints?
So
Are
the
there some that
nature,
are specific to kind of what's motivated the creation of this?
the motivation here, to be very blunt, is the appearance of a double standard, whereby somebody can complain about the property standards in an urban area, but they can't complain about it in an agricultural area. So it's seen by some members of the community as literally a double standard, because it doesn't appear that there's a real justification for complaints about grass being too long, old vehicles, lawnmowers, like anything that you can imagine that would make your property look terrible. What's the difference between it just being up the road versus, like at the lakeshore, as an example?
Right.
So what is the difference between that? And our bylaw says that because it's in an agricultural zone, it doesn't apply. So there was a group of residents who wrote to council and said, I've been told by the clerk several times that this property, we will not, or the township will not do bylaw enforcement because it's exempt. And I said, well, if you don't like it, the way to do it is to approach council. So they approached council. Council considered the issue a little bit. They asked us to track for a year how many do we get? In that scope of time, we did get 2. Like the report says, I've been here 10 years. I can think of like 6 or 8 properties that have been flagged over time. There will have been several complaints over time on the same properties. But again, when there's no authority to act, we don't do anything. I mean, yeah.
So out of the 8,
Yeah.
there are 6 that are of
Legitimate
thick
property
complaint
standards, yeah.
that fall under the bylaw because they are not agricultural.
Yes.
So it could be Saltford, it could be
anything that is zoned not agriculture.
Right.
So lakeshore residential, village
Gotcha.
residential, like
Got it.
all of those
Okay.
settlement area. So it's basically distinguishing between settlement areas and non.
So out of the 6, are 3 of them for one property, or are they 6 separate?
These will be separate.
6
properties,
separate
yes.
properties.
In the list of it, there will be, a few complaints for each one, or
Okay.
yes, these will be for 6 individual.
Gotcha.
Yeah.
So out of those 6,
Mhm.
are the complaints, is there a theme? Like, are they similar complaints for these?
No, they can be different.
They
They
can be
could be
different.
grass. They could be somebody left a dirt pile after
Gotcha.
construction. They
Okay.
could be very.
Just wondering if, is there a common theme here that if we make any recommendations for changing
Yeah.
that, is there a common theme that we need to focus on? That this seems to be a common complaint across
Mhm.
non-agricultural properties.
Yeah.
So, and there isn't
No.
really. Okay. Okay.
Yep.
That's good. Thanks.
Okay, Anita has her hand up.
Just to piggyback on Florence's response, what Florence is unable to capture to a certain degree is what council members' complaints that we get through emails, chatting with residents, letters, that sort of thing, phone calls. And that doesn't get captured in what Florence is talking about, where it was a complaint that was called into the office and recorded and goes through the process that Florence had described earlier. So how do we track those? I don't know that there's really a way to track them. I can probably count how many emails I've gotten in a year. But it would take a fair amount of effort because I don't write them down or anything, but I could go through my emails.
But there are people who have not made a formal complaint using the procedure that is available to them.
Mostly because they know that it's not going to get resolved.
Okay.
Yeah,
Okay.
because if it's exempt, they're not, and they know that for the like the last 25 years, people know that it doesn't apply. So there's no sense filing a complaint because we're going to say, I'm sorry, it doesn't apply because it's agriculture lands. I think if the bylaw ever did get passed, yes, some of those smaller parcels that I spoke about numerous times, that would come out of the woodwork. They go, wow, they changed the municipality now, or they changed the bylaw. Now we can bring forward some of those smaller properties that there have been issues in the past. So I think everyone just got used to it. Well, the municipality doesn't include that as their agriculture part of the bylaw.
Well, the only problem I see with this, a lot of it is just putting a blanket bylaw that deals residential along with the agriculture. They're different lifestyles. Like there's no, what a person in town would consider not normal isn't considered normal in the country. And I know normal farm practicing dealing with manure and that, but there's all kinds of, like, farming is so vague. Like myself, for instance, I don't have a drive shed. Every one of other than my tractors, everything sits outside. Well, is that normal farm practice? Not all my neighbors have drive sheds. I don't. Does that mean that somebody coming along would say, well, you're not a normal farm practice compared to what your neighbors are? You know, that's the problem with putting a blanket exemption. Like, I don't know how it would ever work.
Okay, Glenn, do you have your hand up?
Yeah, I do. Thank you,
Okay,
Mr.
go
Chair. And in a response to the question of Lynn's, I think council received a lot of concerns that we were not treating everyone equally in the municipality, that some were exempt, and that wasn't right. And so that's why we put this together to consider treating everyone fairly. So I just wanted to add that. Thank you, Mr. Chair.
Thanks, Glenn. So anybody else have any comments, questions? Dan?
Just to follow up on what Chris had mentioned there, I agree. A blanket bylaw is pretty tricky with agriculture. I did notice a couple of these bylaws, the one from Central Huron, for example, had a couple sentences here and there regarding vehicles, and it had, but this shall not prevent the occupant of the premises from repairing the vehicle on his own use and whatever. So there is things that could be written possibly to capture what agricultural needs. I'm not sure I'm the guide, but it's just a comment.
Okay, Florence?
I think one thing that I think the committee should consider and look at is the fact, and to me, it's an elephant in the room. There's agriculture, there's urban, and then there's rural living. And I think the piece that's going to be difficult to define and difficult to address is the rural living aspect. It's the small holdings that have little sheds and no places to put things, and they're hobbyists, and they're the ones that are kind of, like, in my opinion, looking at this and working with this for the last 10 years, the agricultural operations are not the problem. They're not the ones that are causing these concerns and these thoughts. It's the little ones in between that don't fall in that, who don't necessarily have a farm business registration number, who, you know, who don't have that piece. In the agricultural zoning, which was provided to you at the last meeting, if you read through the zoning, you will have noticed that in the zoning, there is a lot of special zones. And over the years, when zoning bylaw amendments come forward, the councils over the years would have adopted special zones for certain properties and kind of tagged them as agriculture, but they're not. Some of them, you know, there's a restaurant in there, there's a hotel, like there's different, and it was tagged that because it was convenient, because it's in an agricultural area. So to define it as agriculture, I don't think is right or fair, because it really isn't what it is. I think there needs to be a distinction, and maybe this is where it comes to, is a distinction between an urban, an agriculture, and then a rural living situation. And that rural living situation, I think, is what Chris is really speaking to, that you know, different circumstances, that it is different than living within 60 feet of your neighbor. It's a very different than that. I think it's important to distinguish that this is not, there's several sides to it, and it isn't black and white, and it can't be black and white because it doesn't work. As Dan had said, you know, you read these bylaws and you go across the countryside, and it doesn't work because the rules are there, but they're not being followed. So where do you find the happy medium that works? It's fine to have a rule, but if nobody uses it, then what good is it? Anyway, I'll get off my soapbox.
Okay, thanks, Florence. So Lynn, go ahead.
Thanks, Fleur. I don't think it's a soapbox, because you are holding a lot of the information that we don't have. So I appreciate that. With respect to zoning, how is zoning defined? Is it provincial? Is it a provincial definition or is it local? Is it more local?
So zoning bylaws are defined locally.
Okay, locally by township or county?
By township.
Oh.
Zoning bylaws are township based. So every township will have their own zoning bylaw.
Oh.
How that's mandated is done through the Planning Act, which is a provincial statute. So that's our provincial legislation. So there are rules about how you implement zoning, and every municipality can do it in their own way, except there's always an exception, except that it must conform with the official plan of the township, and then it must conform with the provincial policy statement, which must conform with the Planning Act. So it is very layered.
Mm-hmm.
But within that realm of the zoning, there's room for movement as long as it stays within that umbrella. And so the townships have always done that. It's never perfect, which we know. We live with it every day, but.
Okay, thanks.
Okay, Chris?
Just one question, just for curiosity, what's the process now? Say at Dungannon, say someone had a yard filling full of junk in Dungannon.
Yeah.
What's the process? How do you handle that now?
Okay, so very simply, we receive a phone call from someone. They're really disgruntled. Their neighbor has garbage in the backyard. It stinks. It looks like they got rats, maybe some raccoons, and it's really disturbing, you know, their quality of life over the fence, so to speak. I will say, I need to have it in writing. I appreciate your phone call, but please, you know, I need to have it in writing. So they will submit something either to email, or they'll hand it at the front desk. They'll put their name to it. I receive it, review it, just to make sure where it is. If it is in Dungannon, then yep, that's in a non-agricultural zone. So I call our bylaw enforcement officer. I send the complaint to him with the details of the property. So the legal description, the names of the owners on the property, and he will go and he'll first do a site visit. He'll go to the property, he'll knock on the door, advise that we've received a complaint and this is the issue. And he'll ask, you know, to see it. And if he sees that there's an issue, that if you could please, you know, he'll give a timeline. I'd like you to clean it up within 2 weeks. If nobody's home, he leaves a card. He'll follow up again. If after 2 weeks, the person doesn't clean anything up, then he can either, call again, what's up? Like, why didn't you clean it up? Oh, sorry, I got too busy. I'll clean it up next week. Generally speaking, he will, all right, next week I'll come back and we'll see where it's at. If either the person doesn't want to clean it up or it doesn't get cleaned up, then he puts an order on it. An order is a property standards order. It's a legal document. It gets issued to them, and then there will be a timeline. So he'll say within the next 35 days, you are to clean this up by order of the act. If it doesn't get cleaned up, then then we'll clean it up. Right. If it doesn't get cleaned up, then the township will do the cleanup, and then we charge the invoice that we get. We send the invoice to the owner. Most of the time, they'll pay it. If they don't pay it, that goes on to taxes. Okay, so that's a standard complaint process. It always starts with a conversation. It always starts with the bylaw enforcement officer going up and saying, hello, my name is so-and-so, I'm from the township, and we've received a complaint. Well, who complained? I can't tell you who complained, I'm sorry. I can't tell you who complained, but this is the issue, and we need you to, it goes against the bylaw, this particular section, and you need to clean it up.
Yeah, because I know here in Kinloss one time, I dealt with an older fellow they were having problems with his yard.
Mm-hmm.
And they actually had a committee of 6 individuals from the community come in to decide basically what steps should be taken.
Yeah.
We're more so, I guess, not overrode them, but they worked with the bylaw officer, but it wasn't just up to the bylaw officer.
So it depends. There is an appeal process in place. Okay. So if they decide that they don't like the decision and they want to appeal it, they can appeal it to the Property Standards Appeal Committee, which in ACW is council. There is a process to go through. They have an opportunity to make their case. They come to the podium here, they speak, and then the bylaw enforcement officer will also lay their case out, and then the committee will sit together and decide on whether or not either the order is upheld, it's dismissed, or what can they do in the same way that the board over that James Mitchell was talking about, how there's those 3 kind of scenarios, conditions kind of thing. So there is a property that doesn't actually, in my time here, we've only had 1 appeal lodged. The complainant never showed up, or the appellant never showed up. So it was a great way to refresh the procedure on how that works. But other than that, we haven't done that here yet. So.
Okay, does that answer your question? Okay, Anita?
Florence, you briefly mentioned the farm business registration number, and James briefly mentioned that as well. I guess my question is, to have a property zoned AG, either 1, 3, or 4 in the township, is it required that they have a farm business registration number?
So no. Those 2 are not related. In order to get the farm tax class, you are required to have a farm business registration number through OMAFRA. So, but the 2 are not connected. You don't get agricultural zoning because you have a farm business registration number. 2, and one of the thought processes before we even considered is like, well, how can we differentiate? How can we make sure a farm business registration number allows a farmer to make an income, and to, you're declaring an income on the farm. But when it comes to the normal farm practices, you could have a 100-acre farm with derelict vehicles and all kinds of things in the middle of it that, the owner has a farm business registration number, but the issue of concern isn't part of that normal farm. Like they could be cash croppers, but the issue, they've got something on their property that has nothing to do with their cash crop. So maybe the board doesn't consider that issue a normal farm practice. So having a farm business registration number, to me, would not be a way to distinguish a farm, like a normal farm practice versus not in terms of like enforcing a municipal bylaw. That was my original thought. It's like, well, there's caveats to this. Anyway.
Okay, Dan.
Just kind of following up on all these conversations. In the example of, Dungannon, for example, and you were cleaning up a mess. A lot of farms, there might be some old equipment or old buildings just sitting around. If the owner is in a like, let's say the owner has passed away, so the property's in a state, or the owner is in an old person's home, and the younger generation is saying, well, it's going to be ours someday. The old combines or the old junk is sentimental. Like it happens. It's all the stuff is sentimental. A lot of it is, right? And it's a common theme, I think. How does a municipality, you would say, for example, would go in and clean it up? Well, you can't. How do you go in and clean up it on permission?
That's a great question, because once an order is put on, you don't need permission. It's a legal thing, and it's there. It's not something we like to do. We don't like to put on orders. That's not that's you always try to work it out beforehand. Going in and deciding to clean something up, that's a commitment. Also, I mean, if you're talking farm machinery, that's expensive. Like that would be something, we haven't had to do it, so we've never had the bill. I mean, we see bills for grass cutting, or cleaning up properties, and you get a cleanup crew to come in and they spend all day, and you get an invoice for that. But in terms of having to get like a wrecker to pull out, that I've never crossed that yet. Obviously, like we haven't, and not in the other municipalities I've worked for either. It just didn't happen. I think the statement that sometimes municipal staff we fall on, and I understand that it doesn't quite play out, is that municipal bylaws are complaint based. So as long as nobody complains, things can carry on as they do. But the reality is that if you do have disgruntled neighbors, they will complain and they will cause, and yes. So does that answer a little bit there, Dan?
Somewhat, yes.
Yeah.
Anyway, thank you.
Chris?
Just one more question, just a hypothetical. So when we're on that, say you had a farmer that had, in the back of his farm, or nobody can even see it, had 10 old trucks and some old combines and everything back there, has a neighbor right beside him. They never got along, hates each other's guts. That neighbor all of a sudden hears that we have this bylaw, that there's been a bylaw passed, comes to you guys, issues a complaint and says that guy's got a whole bunch of crap back there. Nobody can even see it. How would you act on that? Like, technically it's a legitimate complaint because he is in contravention of the bylaw.
So I don't like to run into what ifs, because all of a sudden this is being recorded and then I'm, right. And I can appreciate that. I think I don't know the answer to that. I think when a bylaw enforcement officer is called out to a complaint, they have a duty to respond to the complaint, see what the issue is. Oftentimes, as James said, it's a bit of a mediation thing. Sometimes this is clearly a frivolous complaint, and this is a relationship issue between the neighbors. Are we going to get involved in this? Again, a municipality doesn't have to enforce its bylaws. Right? Oh, I mean, I drive around all the time and I see it. Like, I mean, we don't do proactive. And when I'm driving out and about, I don't have my clerk's hat out when I'm driving around. But ultimately there's discretion on whether or not it's acted upon. And if it's very black and white, then yes. But a lot of it is conversation. It's the authority of the bylaw enforcement officer to do it. We have conversation. Is it worth the effort, the risk? Do you look at what's happening versus what it would actually cost to deal with it? Is that worth the issue? Your microphone, don't forget. Yeah, it's okay.
Yeah, so they'd probably just say, it would probably come down to the fact that like, nobody can even see this. Why are we dealing with this?
Why are we dealing this? What is the crux?
Okay.
What is the crux of the issue here? Is this a relationship? Is this what kind of issue are we actually dealing with? You know, that sometimes people think that the municipality can be heavy-handed in what we're dealing with, but ultimately we do consider lots of things like that. We have to. Otherwise, you know, we'd have 4 full-time people doing that.
Okay, Mark and then Anita.
I think Florence captured at the start. I didn't think she was going to, but I think she did. But it's basically case by case. We'd work with those folks, and I agree that at the end of the day, a pile of vehicles in the bush isn't really affecting anybody. And not, I think we would look at that and say, hey, and Florence said it earlier that just because we have a bylaw, we don't have to enforce it. So
Anita?
The same question and issue came up in the short-term rental committee that we dealt with, exactly that question, Chris. And I think the answer was exactly what Florence had said this evening, was that the bylaw officer seems to have a handle on what is vexatious, frivolous, just, you know, just being a nuisance to the neighbor. And I think they've determined that that bylaw officer has a pretty good handle on that.
Just to say, like, logic really has to prevail, right? Like, that's kind of what the whole point is that what seems logical, like it needs to have not just the appearance of being fair, but it actually has to be done fairly, and reasonably. I mean, every time a bylaw enforcement officer goes out, they charge the municipality for it. Like, it's not free, you know? So we have to judge, is this worth the expense on the budget for this?
Okay, I have a quick question. So a resident brought up to me when so a person that files a complaint, the owner never finds out about it, right? Can that, so like his biggest beef is that they should have to file some money to put a complaint in. Does any other municipality do that?
There may be some fees associated with paperwork later on, or like once orders are issued, fees may come with that just to deal with it administratively. But in principle, just like James said, a complaint in principle, you shouldn't charge for that.
Mark,
are you saying the person that files the complaint has to pay a fee?
that was his thoughts.
Oh, yeah. Yeah. So I would say no.
I mean, when you compare like an Ontario land tribunal, you know, if there's a zoning bylaw amendment that comes forward, you know, in order to file appeal, you have to write a check for $1,100. That's just how it works, because it goes to Toronto and they have to pay for the system, which is supposed to be a user pay system. I'm going to go down a different train. I'm not going to go there. But the point is that a complaint in principle, if something isn't right, it is the responsibility to go investigate. And in principle, I wouldn't charge a fee for that.
Okay, I didn't think it was right either. So, Mark?
Just to clarify, Florence is talking about fees and charges after the investigation went through and there was charges for the administration of it. But back to your question, was there a fee just to file a complaint? And the answer is no.
And no other municipality does that, correct?
I can't be sure. I don't think so. Like, that doesn't seem like a common thing. Definitely administrative fees after the fact, like once an order's been issued and it becomes something that a file is really created, and that, you know, they may charge $200 for, here's your order and here's $200, you know, for me dealing with this. But no.
Okay. Any other questions on, we're still on 5.3, right? Any more questions? All right, so we'll move on to 5.4. So this is a report done by Kelly and Florence, right? Kelly, just you, Kelly? Go ahead, Kelly.
Yeah, so you have a draft of the proposed flyer that we'd like to include in the tax bill that is going out in February. So yeah, open to your comments.
So my first problem is the open house. That's when Good Roads is on. We're gonna go down this Saturday before, but
just a minute here.
But that's fine, like I don't have to be there.
Yeah, these dates are subject to change, but this, like, if the board was, the committee was in favor of the proposal, we can jiggle those dates around. This is just kind of a tentative thing to move forward. But I guess the first thing that Kelly has on her list is the flyer that everyone got in their package, and yep, in that flyer there, if the committee is okay with that, we would go ahead and put that in the tax bills that are going out in the next couple of weeks. But at the timelines in there, as long as the committee's okay with the timelines, give or take here and there, that's fine. I know I look at it too, and it's finalizing the things in April, and I know Dan brought up at the last meeting, and I think I said we can pump the brakes if this isn't going to get done in time. We can pump the brakes and reconvene in the fall. But I think just a general consensus if this is kind of if we're the folks in this room want to go ahead with this committee.
Lynn?
So I'm reading the committee report. Was there, excuse me, was there an actual flyer that I missed or attached to?
It's at I think it's the very last page.
Yeah, yes, it is. It's the last page in your package, 165. It's the property standards.
Oh,
ad.
okay.
Yep.
I'm
the nice red
I'm
card.
linking to it off
Click
the
into the
agenda.
second. And
This one?
you were right where you were.
Right here.
The bottom one, the other one.
This
Yeah.
one. I'm sorry. Gotcha. Okay. Thank you.
So the committee's receptive that we would put that in the next tax bill that's going out shortly.
So my understanding, just from listening to the recording, this was the idea, the reason why this was put in is kind of in lieu of that postcard, right? Was that the idea?
Right. We talked about the postcard last meeting. We thought, well, if we got this done, maybe we don't have to, because the postcard, I know it's a good purpose, but it costs quite a bit of money. This is the most inexpensive way to get it out here. And that way I think we talked about it last meeting about the communication. Well, this would get out to all residents because you get the tax bill, whether they read or not, you can't force them to. They might just throw in the garbage, but you never know. At least they've been told. So
everybody's good with that?
Mr. Chair?
Okay, Glenn, go ahead.
Yeah, thank you very much. I like the information flyer. Is the commenting period long enough? And that's a question to the group and staff. Thank you.
What was the length?
yeah, so in the actual newsletter that going out, I don't think it refers to any specific dates, but I think you're referring to the report, Glenn, and in the report it shows the timeline being proposed. Where are we here? Hold accept feedback till you're saying the commenting period from March 15th to April 12th isn't enough time. Is that what you're saying, Glenn?
Yeah, that's my question. Is that enough time is that long enough? That's my question. Thank you.
Okay, Lauren?
So in our experience, when you have commenting windows that are really long, you have a heightened in the beginning, nothing happens in the middle, and a heightened at the end. So you may as well just shorten up that window and get what you need in the meantime. Keep the, otherwise it drags on and it doesn't have to. So.
Like it is almost a month. I think that's plenty of time. I don't know what everybody else thinks, but. So everybody's good with that?
So we're good with the flyer and we're good with the kind of the draft timeline here. And again, like I said earlier, some of those dates may be jiggled. Like if March 28th doesn't work, we can move that to a different date. It's up to the committee. We will meet again and we'll determine that at the end of this meeting too. So, and Kelly's got her hand up.
Let's see. Just looking for some feedback. Does the open house have to be a Saturday or could it be an evening? When I know we probably would want to aim for March when before farmers, because hopefully there's nice weather here soon and they're outside in April. But yeah, just looking for some feedback.
Does anybody have any Lynn and Dan?
I was just going to say, I probably wouldn't want to come out on a Saturday. I'd probably be more apt to do it on a weekday evening. That's just me. I don't know if it really matters.
I was gonna say the time doesn't matter to me. I was gonna ask the question was typically what has ACW done in the past for open houses, what day of the week or time? But I guess as a comment to Lynn there as well, a lot of people do work and 9 to 5 or whatever. They might want to say they want to come after hours. So what works? What was ACW done in the past, I guess, for open houses is my question.
Can start.
Yeah, I think, you know, we have had them Saturdays, but we also have had them in the evenings too. So it's either or. And you know, if it doesn't have to be a Saturday, I think sometimes when, if we have Saturdays, we're trying to attract everyone. But again, this is March as well. So we're not going to attract a lot of the Lakeshore folks because they're not here. But this is about agriculture but I would say we're open during the week too. Like Lynn said, the weekend may or may not. Like and back to what you said, Dan, that most people work. Like we could start something later in the day and just have it during the daytime, but also the night. So it kind of starts the night. Like we had an open house the other night for a gravel pit thing, and it started at 6 and it went to 7:30. So but we could start earlier and go from there. It's whatever the committee wants.
No, you pretty much said what I was going to say. But
You're amazing.
I know. It's pretty much whatever you want. We've done Saturdays, we've done through the week. You know, it just depends on the audience that you're looking to capture. Short-term rental, we really wanted to capture Lakeshore, and that meant a weekend when they were going to be here. So, and Glenn's got his hand up.
Okay, go ahead, Glenn.
Okay, thanks, Mr. Chair. What I kind of I wonder if a Saturday morning kind of works with the majority of people, and I'm thinking like a 9 to 12 or whatever. What about the week before the 28th? Would that be a conflict? Thank you.
I don't really want to we don't need to hammer down these dates right now. I think this is just draft. Like I think let's get into the whole process and see where we're at. There's no sense hardcoring a date right off the bat. I think, but I think if and when we do have open house, I think we need to be considered. What does it have to be Saturday? It can be a weekday. It can be an afternoon into an evening. It doesn't have to be a Saturday morning. But I don't think we need to hammer down that date. I think we just need to know kind of like the timeline, and that we'll move that forward and see how things transpire.
So I just wanted to reiterate, as we're going through this, that I think the idea is that the committee, the working group, get a real handle on what the actual issue is, what the issue is, what the rules are around, what's in the way. And once we have the handle on that, then we ask the public or whoever it is that you would like to ask, all right, these are the issues. What are you seeing and what are you afraid of? Where do you think your rights are going to be infringed? Like what are your issues? And then that comes back to the committee. You're going to talk about it and then recommend something to come to council. So the commenting period, the open house period, that doesn't necessarily have to happen after you do certain thing. I think it should happen just as you become really acquainted with the topic, but it doesn't have to happen in a certain frame. With the short-term rental committee, we had a bylaw prepared as a draft before we went to an open house. So I think that was a bit of a different situation here. You're hearing the feedback, you're gathering the information that you need in order to make a recommendation. So when the date is, we'll get there. I think it would be worth having at least one more meeting with some information, like the cases that you had suggested, and to have a few more conversations after everybody's had a chance to think about it a little bit more. Then we can keep, and I think it would be more appropriate to finalize those specific, the commenting period, maybe not, but definitely the open house. I think we could finalize that at the next meeting, what date that will be. I think it's a little preliminary at this point.
If you mind, how was your open house for short termers? Was there a lot of people went, or was it just a waste of time?
Oh, we had 50 people maybe.
I was going to say more
than that. 70 people.
I had 80 in my head. Yep.
Yeah.
Okay, that's all I need.
We had a great turnout. again, that was very focused on a kind of a specific section of the municipality. So that might look different for, that would look different.
So was this public meeting in this building or was it at a hall?
Yeah, it's not a public meeting, it's an open house. Because there's a difference between a public meeting and open house. We wouldn't have it here, no, we would have it at another facility. And I think Kelly put in there where we'd have it, I can't remember what she said. Yeah, perhaps Lucknow. We would have it at a facility. We don't usually host open houses and things here.
And the other thing there's no dates on this flyer, so you'd be putting the dates in when we have them
That's right.
and the time.
I think the intent of the flyer is to make it very well known that this is happening. I also just want to shout out to the Huron Citizen. If you read it 2 weeks ago, it was on 3 of their pages. The second page, the page 23 and 24, and there were 3, like, they captured it really well. So, and I believe the Huron Citizen has approximately 300 subscribers in ACW who get that weekly. So I think that was a great, thanks, Scott. I know you're listening, or you will be anyway. So I think that was a great way to get it out there. If you didn't get a chance to read it, I think you can get it online. You might be able to see it now. And has a great synopsis of the first meeting. So, and it really gives a context of what's being talked about. Did I say the Huron? It's Huron Citizen. Yeah, the Blythe Citizen, the Huron Citizen. So, which I think it's appropriately named, definitely.
Mark?
So just following up what Doug said, like this is basically to go out with the tax bills and say, hey folks, we're looking at this, stay tuned, keep your ear to the ground. We may not have all the dates and everything ready yet, but stay tuned. So those people that are really interested in it, they're going to be reaching out to us and we'll be reaching out to them later when we get all those dates. But it's just to say, this is what we're thinking about, because I think about what Chris says. He goes to the restaurant or wherever, he said the coffee shop, and nobody knows about it. But if they get in the tax bill, this is kind of telling people, hey, we're talking about this.
One more point. If at the next meeting, say, so it starts to get out there, we've got the news piece in the tax newsletter in like an insert. Maybe we still do the postcard with the actual open house date. But maybe that is something. Yeah. The newsletter will go out the second week of February, 2nd or 3rd week of February is when the tax notices go out.
So any more comments on
If the
that?
committee's okay with that newsletter, then Kelly's going to start printing tomorrow morning.
So like, when does the tax bill go out? So said it started on the 12th till the middle of March, or February to the middle of March, right? So then your first week, you're not going to have nobody commenting, correct?
No, you're on the wrong month. So the tax bills go out in February. Yeah. Okay. The commenting period doesn't start till March 15th. We're in March. We're gonna have nope. We're gonna have another meeting between now and the end of March. At the end of February, sorry. So the commenting period is from March 15th to April 12th.
Okay, I was wrong on that, sorry.
That's okay. I like calling you out when you're wrong.
So we're all good on that?
Okay.
All right, so we'll move on to the date of the next meeting, right?
Nope.
No?
I'd like direction as to what you require for the next meeting.
I know one thing Doug had brought up about the 5 decisions, the last 5 decisions. So I think you already had that down, Florence, but if the committee agrees that, we go ahead with that. And maybe I'm just coming up with my thoughts, and then I want the committee can add to it. And then maybe Kelly could come up with what the cost of a postcard is. If the committee thought that was worth the while, you could have the cost for that. And I'll let the committee members add to that.
Anita?
I think it was at the first meeting, direction to staff was about delegations. I can't recall off the top of my head if Dr. Wayne Caldwell was on the delegation list. I didn't think he was, but I wondered if this committee would consider having staff reach out to him and ask him. I know that he seemed, if I recall in his letter, he seemed interested in being on the committee, but he couldn't commit to the timeline. But perhaps he could commit to presenting a delegation.
I think that would be worthwhile doing. Dr. Caldwell is a rural planner, so he has a very special lens on this type of area. I would be I can reach out to him and ask him if the committee is so inclined. I can definitely do that. See if he'd be interested in attending.
So he won't attend in person. He'd be like the James,
All depends. He may be down the road. I don't know. Depends on where he is.
but he could attend like James did.
Yep.
As a Zoom call.
Yep. It does make it very easy.
Yeah.
Yeah, it really does. So I'll take the nod of heads as an agreement. Yes. Okay.
I wondered if we wanted to do a bit of a deeper dive into looking at those different zone classifications. If potentially we would be looking at altering, or we're making a recommendation to alter the bylaw to encompass, or maybe not,
Yeah. I think what I would
different zones,
do.
or is that something we want to look at and look more at what the specific definitions are of those that are exempt and those that aren't?
I think that's worth, so what I would do is I would bring back the zones, because I did provide them at the first meeting. We'll put them back on the agenda. And then I think it's worth the conversation, because I think the definition of an agricultural zone is not the appropriate thing to use for it. That's what I'm hearing. So I think it's worth having that conversation about zoning and property standards.
Yeah. I wondered also, Florence,
Yes.
is there something you think we should be looking at? Because you have, like I said, like you have more experience with what's happening. Like, is there something else that we haven't touched on that you think we need to?
I think it's the zoning that needs
Okay.
to be looked at.
So Florence, on that, you would bring back that same definitions and those zonings from the last meeting just to take a deeper dive into that?
Yeah.
Okay.
Just a comment regarding the zones AG1 to AG4. Does the Huron County GIS map, does it show the different zones if we click on it? And what I'm getting at is I could do some homework,
Yes.
before the next meeting and see that.
Let me just, do you want to just have a look and see if the public portal shows it? I know ours, it should.
So while Kelly's looking that up, are there any other suggestions for the next meeting? So what I have is the 5 decisions, the postcard, possible costs, Wayne Caldwell invite, and bring back the ag zones for looking a deeper dive on the definition. I'm just killing times.
I think Kelly's having a look at it. I think as long as you can, I think the only thing that you can't see is the ownership. So you can see the zoning. So if you go, the Huron County GIS system, looking at nods if those are familiar with it. If you go there and you start clicking on properties, you will be able to see, if you turn on layers, you can turn on the aerial and you can look at different properties, and then you can see what their zoning is. And there should be a link to the zoning itself. When you click on it, it should bring up the document.
You do have to click on planning for
Yes.
for the zoning to
Yes.
be activated.
Click the planning layer.
Yes.
Yeah.
And that's to the left.
Okay, that's good.
And then we do come back, maybe the next meeting, we maybe revisit the timelines and
Yes.
see where we're going.
And then revisit the timeline. So I'll put that on there just as it will be an agenda item to make sure that we address the
dates and everything, right?
And do we want to draft the type of public feedback we want to receive? Are we there yet?
I didn't catch that. You went very...
Draft the questions that we want to ask for the public feedback.
Maybe that should be homework for the committee. Um,
Oh, I feel like we're in school.
I
again.
know, this is not council, so this is a different game. Um,
I think that's a very good idea, because what kind of questions do you want to ask the
what
public?
kind of question? So maybe the committee should come, we'll have it as an agenda item, but the committee will be tasked with what kind of questions would you ask your neighbors about this? If we want public feedback, what is the feedback that you would like to hear? What are the questions that you would like to have in order to, and then we'll take those questions and then we'll put them in that public week, in that the
Postcard?
survey.
Yeah, the postcard?
We could do the postcard or it'll be a survey, which would, maybe the survey would be on that postcard with the open house information. And then, yeah, so that'll be, or at least the starting point for that survey. So,
Sorry, are
the
you
committee.
talking about the information you're going to gather for that 30-day period between like mid-March, mid-April?
Yes.
So then what will the open house want to gather?
So the open
What's the
house would be
difference?
very similar. Basically, you would be there as a committee, having an understanding of the issue, hearing the feedback from those who are concerned, knowing full well that you don't have the answer yet. You won't have it yet, but you're taking that feedback, those conversations, so that we come back to this table as a working group and say, okay, these are the issues that we heard. I think it's really important to recognize this in the bylaw or not to recognize this in the bylaw. And then we word it from there. That's the vision.
Do you, like the three of you as township staff, have an idea of what those questions should be?
Not in this context.
Okay.
I think that is the role of the committee, and it is the role of the committee to do that. Yeah.
If I think of one, I'll add it to this.
If we think of one, we'll add it to the conversation, but I think it should stem and be rooted from this group. Okay. Questions. All right.
So that's 6 things: the decisions, the postcard, Wayne Caldwell, egg zones, timelines, look at that again, and perhaps the committee's doing their homework and bring back some draft questions that we can put out there.
So like these draft questions, that's what people are gonna ask in that month period, correct?
It would be the content of the survey. So you would, and we may do a little bit of tweaking just to, get grammatically or whatnot. But if you say, when you hear that property standards are going to change, what concerns you? That might be a question. Or what do you hope that the township will achieve by changing? Or do you think it should stay status quo? That's a question. I should stop now because you guys need to be the ones giving the ideas, but that's kind of along the line. So if you were to have a conversation with someone, knowing the context of what's going on here, what would you want to get from them? And
So that survey will be on here, or where are you gonna get that?
That newsletter, you're pointing at the newsletter?
Yeah.
Yeah. So that's just going out there saying, hey,
Yeah.
we're talking about this, folks. Stay tuned. Okay. And then at the next meeting, we'll talk about the survey and what the questions might be, and then how we're getting it out to the public. And that'll be part of the communication plan, as in the timelines and everything else.
I'm as clear as mud now.
okay.
So anything more you want to add to the next meeting?
I would just say
Good.
the questions are kind of open-ended to direct the feedback
Yeah.
from ratepayers.
Exactly.
Okay.
Okay. Next meeting.
All right. Next meeting. When? So I take it'll be sometime in February, right?
Oh, yes. And it could be any night and it could be any time. So I know we have a meeting at 4:30. The committee doesn't want to meet at 4:30. That's one thing. But Curtis Blake, the chairperson, isn't here. He sent his regards. He got tied up.
Like I know Doug, you said something about it a little earlier. That's fine with me. I don't know what the rest is or township staff or
I know, I think
as winter drags on, who knows what.
Yeah, staff, we're very adaptable, so I guess it's
I'm
let the
gonna
committee.
I'm gonna suggest we keep it the 4:30 time. I know it works for Curtis. He's not here to speak for himself, and I think everybody else can be here, so I think it's appropriate to leave it at that time.
It's Thursday, the best day.
It not Tuesdays are preferably off.
Yeah, Tuesday's long enough. Sorry. I guess it's up to the committee if Thursdays won't work. It was just that we had to start somewhere, but it's up to the committee members. If Thursdays work, if they don't work, we're looking for options, but probably not a Tuesday.
Tuesday the 19th and March 5th, but I can't do the 26th. Keep it on Thursday.
19th would keep the ball rolling.
Yeah, and it keeps the ball rolling, and the list of things that we have to do isn't a lot of extra work, so we could probably make that happen if that works for everyone else in the room.
That's February 19th.
Yes, Thursday at 4:30. Is that when? Yeah.
Everybody's good with that? I'm seeing all nods. Okay. So the next meeting will be February 19th at 4:30 in the afternoon. So the next one's adjournment. I need a mover and a seconder for that. Doug and moves and Dan seconds. That the Agricultural Property Standards Working Group will now adjourn and meet at February 19th at 4:30 or at the call of the chair. All in favor? Carried.